We're going to start our next panel, which is the financial reporting and accounting fraud, a core enforcement focus. Should I keep going? All right. We have, as moderating this panel, Steve Richards, who's a senior managing director at Ankura Consulting Group in DC, and he previously served as the assistant chief accountant at the SEC. We have Asheesh Goel, partner at Kirkland and Ellis in Chicago, and he previously served as an SEC branch chief. Paul Helms, partner at McDermott, Will and Emery in Chicago, who previously served at the SEC in roles that include enforcement attorney and counsel to the director of enforcement. And McKinley, assistant regional director at the SEC's Chicago regional office. And finally, Paul Tzur, partner at Blank Rome in Chicago. He previously served as an AUSA for 9 years in the U.S. Attorney's Office for the Northern District of Illinois.
All right, so as everybody's trickling back in, this is going to be the best panel of the day, so hopefully everybody can make it. Just a few opening remarks here before we get going is, look, the goals and objectives here today on our panel are really focused on, with the core ask here, financial reporting, disclosure, accounting. What we're trying to do is make sure that we're sharing perspectives from our experience and what we're seeing, and having the benefit of having Ann here from the SEC's perspective for the benefit of the practitioner, because there's a variety of folks here from outside counsel, internal counsel, audit firms, and the like. And really sharing those perspectives, hopefully that are helpful to give you some perspective. And so with that, I think we'd like to start off and take advantage of the fact, Ann, you're here with us, and appreciate your service and the time, and especially over the last several months, the uncertainty, your commitment to the investor, and always treating us, because I've had the opportunity to be in front of you, fairly, and always focus on the right thing, so appreciate that, you and the staff. But if you could give us some opening thoughts about relative to, going back to the basics, what's some of the Commission's perspectives?
Thanks, Steve. And before I begin, as always, I need to give the SEC's disclaimer. I am providing remarks today in my capacity as an acting associate director in the Division of Enforcement. My remarks do not reflect the views of any of the commissioners, the Commission, or any other member of the SEC staff. And so with that, we have a relatively new chairman. He's only been in place for a few months. We have a brand new enforcement director. So it is fair to expect some changes and adjustments. But our focus is and will be on the core mission. And just for anybody in the room who doesn't know what that is, it's taking action on behalf of investors, anyone who is harmed by violations of the federal securities laws, deterring fraud, and deterring manipulation. It does bear emphasis, the work of the Division of Enforcement has not stopped. So the SEC has a long track record of investigating and bringing actions in cases that involve financial and disclosure fraud, really regardless of any particular administration or particular commission. Those cases really relate to companies who are expected to provide true and accurate information to investors. This includes their disclosures in public SEC filings. It includes their disclosures in press releases. It includes their disclosures in other investor materials, and all of the financial disclosures that are required to be in those materials. So we're going to continue to investigate any disclosures that are potentially false or misleading. We'll consider whether there's been scienter fraud, whether there's been non-scienter fraud, and there is going to be an emphasis on paying particular attention to individuals and whether they are accountable for anything that takes place in the company. We'll also be looking closely at the possible manipulation of financial performance. This would include inflated performance metrics, disclosures regarding impairments, expenses, losses, and any false books and records. And then in the context of financial statements being prepared in accordance with GAAP, we're always going to be interested in the internal accounting control environment, understanding the systems of internal accounting controls and what they provide, and reasonable assurances that the company's financial reporting actually accords with GAAP.
Well, let's pick up on a couple of those themes. You talked a bit about disclosure, both inside 30 Act, 34 Act filings, but also outside of 34 Act filings. And I'm sure the audience is familiar with the Nicola case. And so maybe let me turn to you, Asheesh. How should issuers and counsel think about those kinds of disclosures that are not in the four corners of a document in the 34 Act?
Yeah, so I think that area is confusing, to be candid. The guidance is not clear at all on this, but what's interesting about it is it sort of goes back to the fraud on the market doctrine, right? There's a view that's been espoused by the SEC and other securities practitioners for a very, very long time, an economic theory, that any statement made by the company is immediately and rationally incorporated into the share price of a publicly traded stock. And so historically, and I'm harkening back to 20 years when I was at the SEC, we focused on statements made in SEC filings, 10Ks, Qs, 8Ks, and the like, proxies and registration statements. And we tested whether those statements were true and accurate, or if they were misleading, whether they were intentionally misleading. I think what's happened, really, since I was there, was obviously the internet exploded, social media exploded, and the ability for executives of all levels to communicate with shareholders and the market and the constituents has multiplied dramatically. And the speed of communication has changed dramatically, right? So before, you would think like 5 times whether you're issuing a press release, because then you have to 8K it, and is it material, and all those analyses. There were a lot of protections around that. Now you have CEOs, but also non-CEOs. You have marketing managers and finance directors alike who are tweeting or posting, and I think that poses a real technological challenge, both for companies from an internal controls perspective, but it also poses a challenge from the SEC perspective, right? So you mentioned the Nikola Motors case. It was a case that I represented the company on. In that case, which is now a few years old, the CEO was using social media to talk about what was going on at the company. Very directly about company-specific things, like, tweeting things like, we have put solar panels on the roof of our facility. And we did an internal investigation. Ultimately, the SEC did an investigation as well. In fact, several of the SEC lawyers are here right now. And we learned that there were no solar panels on the roof at that time. And so what do you do, right? So that's a statement made about the company. It's a renewable energy company. Solar panels are relevant. You start sort of thinking about materiality and how the SEC thinks about materiality in the context of social media posts is really open. And not all posts are equal, right? We had instances in other cases where executives were live streaming earnings announcements. Those have probably a little more protections, but now you're talking to a retail market, right? You're not talking to analysts. Some of them were taking questions on Instagram, right? So that creates a lot of complexity, but I think as we advise our clients, we work very, very diligently to focus on internal controls around social media posts. And I will tell you, if your client is somebody like Elon Musk, that's very hard. He doesn't necessarily listen to lawyers, or at least that's been my experience. But a lot of CEOs are super sensitive to that. And so really baking in some controls are really the best thing you can do here, because once the statements are out, then you're sort of in a difficult box.
Yeah, well, let's pick up on the point you're just making about baking in some controls and the disclosures, controls, and procedures, that kind of thing, especially when you're dealing with all the social media, TikTok, Instagram, the nature and speed of how the leadership is communicating with the investor and other users of financial information. Let me turn to the Pauls, Paul T and Paul H both. And when you guys think about the control environment, how are you advising clients in this kind of dynamic environment where social media, it sometimes is the first instance of information coming out to users of financial information? How are you advising your clients relative to how do you control that?
Which Paul do you want to go first?
We'll start with Paul H.
Thank you, and thank you for having me here. I think we have been talking this time last year, and certainly the year before that, a lot of the warnings would have been about your internal control and disclosure control environment, that it was a way that the prior administration was really expanding the waterfront, particularly on materiality, as Asheesh mentioned, and it was sort of a danger area. I think the time of using internal and disclosure controls to bring cases on the edge is probably done. at least for the time being. You need to be careful with that because, as was mentioned on the last panel, these investigations have a long tail, 3-4 years. But I think the place it's still going to be, of interest is going to be where you have a case where, again, a CEO, a CFO makes a statement through social media outside the normal channels. And I think the best way to do that is the one Asheesh mentioned, which is really start to put some controls. And one way to do that is to tell the CEO or CFO, the SEC thinks in terms of statements and who made the statements. And so if you want to be on the hook, go ahead and go out there on social media. If you want protection, let's set up a system where you can still get social media posts out, but we make sure we draw a straight line to what backs up that statement. And so one of the pieces of advice I give clients is when you're thinking about a 10K, a 10Q, an 8K disclosure, really try to draw a line from what you're putting out to what the board is seeing, which then presumably locks in what the board is seeing to what management told them and had a basis for it. And so then you can present all that at that point in time. I think that's harder when you're moving faster, as Asheesh mentioned, but I still think it's very important to at least make sure your social media posts are aligning with what your board and upper management is seeing so that you have a basis for when the government shows up or when a private plaintiff shows up.
I also, just to chime in and add in a little bit, Paul, what you're saying is it really matters what the post is about, right? So if you're tweeting, your earnings announcement in advance of your earnings announcement, that is going to get scrutinized, right? But if you're sort of building a relationship or a rapport with a particular segment of the world, a customer base or a client base or what have you, that's very different. And so I think that's that's where the magic is, I think, as advisors. Is, I have a great client, I won't mention the name, but he's the president of a very large publicly traded private equity firm, and he posts videos of him running in different parts of the world. And he talks about things that are interesting to him and what's going on in terms of like how this particular market might be interesting for their opportunities at the company. But it's pretty generic. And that kind of stuff is always going to be fine. And so it's really what the post is about, and really drawing some bright lines internally can really help. Because to your point, Paul, there's a speed point here. Like a lot of my clients are saying, like, Asheesh, I'm not going to wait 24 hours for 5 lawyers and 3 accountants to vet this. I'm posting about I'm in Singapore and I want to go running, right? And I want to post. And so you have to sort of like say, it's important to be nuanced, I guess, is to say, if you define boxes, a particular set of boxes, you're fine. If you're posting about your family, your kids, those kinds of things. Then there's stuff that's clearly not going to be fine, like front-running earnings announcements, right? But then there's stuff in the middle, and I think that's where you start getting more nuanced.
See, I don't think it's that hard to find the line. If you're posting, and thank you, Securities Docket, for having us all here and turning us all into an aha video, or most of us into an aha video. If you're posting, if your CEO is posting about his travels and about his thoughts proactively about a market, about an industry, I agree with you. I think that's totally fine. If your CEO is posting a TikTok video with Ariana Grande announcing a new product launch on a date certain and how that product launch is going to increase the stock price by 20%, that is a clear, it's maybe not a violation, but you are running into the SEC laws at that point. I think any time that you start talking about the performance of the company or the products that you might be launching or the financials of the company, there are clear categories of things that you can announce to, in terms of controls, announce to your team, announce to your ELT that are just out of bounds, that you cannot talk about publicly. And it's easy to think about what is driving all this. For 91 years, since the 34 Act, the rule hasn't been what you put into financial reports is what gets scrutinized, and what an executive says outside of the financial reports is totally fine and not considered by the commission. It's the other way around. The point of the 34 Act was to give an avenue for companies to provide these statements to the market and for the SEC to help oversee those statements at a time when there was no technology to give that information the way we have today. But the rule has always been, if you are making a statement about your company as an executive, whether a CEO, CFO, anywhere down the line where you have knowledge about the company, you better be sure that it's vetted. You better be aware that the SEC can enforce the statement if it is a misstatement, if it's not protected by the standard disclosures, the standard forward-looking statements. And so you really need to, in the compliance field, really need to educate your ELT and anyone else who might be out there with inside information about the company about how those statements are going to be viewed by the public and by the SEC. And just, you need to be very, very careful in making them.
Maybe let's turn back to Ann just a little bit here. On when the commission does see disclosures that are inconsistent with what's in the four corners of the document, 34 Act documents, how is it evaluating those different social media posts and other things?
So it's always going to be facts and circumstances. We will look at the particular facts of the particular matter, but I will say, if the company and the executives are disclosing information that's false or misleading, especially when that is information that would be important to investors or could cause investor harm, that's going to be the type of thing that we will take very seriously. And I think another thing that we will look at very closely is if the company internally is saying one thing, forecasting one thing, but externally to investors is saying something completely different, usually probably much stronger to investors. And if that's the case and the executives are doing that, that's a fundamental failure and something that we would take very, very seriously.
Yeah. Well, so we talked a bit about social media and some of the other avenues and velocity that companies can get information out. Let's pivot a little bit towards non-GAAP financial metrics, which has been a priority of the commission for years. But starting maybe with you, Ann, will the commission continue to focus on non-GAAP metrics, given their continued prevalence and importance that companies are putting, stressing those KPIs?
Sure. So I mean, Regulation G, I think item 10E of Reg XK, those are important rules. They are still things that we are focused on. And like any other disclosure, if you're going to say something, you need to fairly present the financial condition of the company. The information has to be accurate. And again, if management chooses to tell a different story internally than externally, anything you're saying, we will take a look at.
Yeah, and maybe Paul Helm to touch on this. How should, when you're advising your clients, how should issuers and counsel think about these types of non-GAAP disclosures where you're talking about an operational metric, clicks or subscribers or those kinds of things? How are you advising your clients to think about that risk?
I want to step back for a second. I think, I don't want to speak for the SEC either, but I feel like the SEC generally thinks about accounting disclosure cases as either a financial statement, a GAAP case, or a disclosure case, right? It's sort of one or the other or both. And for me, personally, the way I think about it, the non-GAAP metrics fit somewhere in between those two things because of Reg G and because of the rules that are around it, as Ann mentioned. And yet it also has some of the flavor of disclosure, right, in terms of, hey, we're adjusting our normal metrics and the ways that you mentioned. Chair Atkins has been pretty clear in prior statements. I just think the kind of the background he has, he's going to be a fan of non-GAAP statements. He sees them as relevant to evaluating as a very pragmatic thing the market does. We use EBITDA, we use other forms of non-GAAP metrics, we use some of the other non-financial metrics. I think he's okay with that from a business standpoint and lacks some of the skepticism that I think you will face from line staff on this, right? Staff accountants in particular, I think don't love non-GAAP metrics, right? They just come to it with that bias, and I don't mean that in a negative sense, just in an objective way. They prefer GAAP. And so I think you have to be very cautious about making sure, and to me, the way to kind of straddle the line is really look hard at Reg G and work hard with your consultants, with your accountants, and with the folks who do securities law counseling at a level I don't do, right? They spend all day with securities filings, and make sure that you've really buttoned down Reg G from all its various, all its wonky technical rules. And I think if you do that, I think at the higher levels of the SEC, you're going to be safe because you're going to be able to get out of some of the cynicism in this administration that you will face at the line level.
Let me ask Paul. Let me ask you a quick follow-up. Is just Asheesh rightly, I think, brings up some of the lack of clarity around materiality when you're talking about these social media information. How do you think about when you're advising clients on materiality relating to these non-GAAP measures?
I think if you're putting a non-GAAP metric out there, you're usually doing it because you think the market cares about it. And a lot of times the way you get in trouble is adjusting a non-GAAP metric in a way that the market's going to pay attention to. And going back to Ann's comment, that's, if internally in your board meeting you're talking about this metric and it matters to you and you think it matters to the market, that's what it shows in that internal dialogue. The staff is going to get that eventually, and private plaintiffs are going to get that. And you've got to make sure all of that aligns.
Well, let's shift a bit back to, because we did this with the social media post. When you think about the control environment, disclosures, controls, procedures, Paul T., from your perspective, when you're advising your clients to think about these kinds of non-GAAP metrics and how that intersects with your internal control environment, your disclosure, controls, and procedures, what are you stressing to your clients about areas they need to be focused on to mitigate some of those risks?
So to echo what Paul Helms was saying, I think what matters is the reason why my client wants to provide this non-GAAP information in the first place. What's the reason? There are times where my clients don't have a good answer for that other than, well, that's just what we've done for quite some time. I think it's really important, and this goes to the controls question, really important to think deeply and repeatedly about why it is that we are issuing this non-GAAP information in the first place. Because the risk to it is also what Paul was just talking about. It's not audited, it's not vetted in the same way that GAAP information is. Nor is there any real correlation or clear line of how that information that we are providing might actually impact stock performance, might actually impact financial performance. Maybe there's an obvious answer for it, but that's not always the case. And so I think from a controls perspective, and it's hard to put clear language on what this control might be, but we have to be thinking about why it is we are providing this information, how it is we can be sure that this information is accurate, and what impact are we trying to drive with our investor community.
Yeah.
And Steve, on one point on that, if a company is choosing to speak, or even more, choosing to declare a topic as important to the company, to its investors, they have to do it truthfully and accurately. And that's something that really will be our scrutiny.
I think the challenge around that is, though, I will say, is especially since sort of the late 90s dot-com boom and then bust and then boom again, there's been this massive proliferation of non-GAAP metrics used by startups. And some of these startups are billions of dollars market cap. But every industry has their cadre or cohort of non-GAAP metrics, right? So if you're in the housing sector, it's lumber costs or whatever, right? It's various different things. In the tech sector, it can be how many customers have subscribed. In the EV sector, it was, well, how many people have paid a deposit for an EV? And all these non-GAAP metrics are critically important, right? You have companies that have no revenue, that have no money, that are worth billions of dollars because of non-GAAP metrics, because investors care. But what's interesting is when the non-GAAP metrics cases have, usage has exploded, the stuff coming out of the SEC is uneven. And so, we all practitioners in this room, whether you're an accountant or lawyer or not, or neither, and focus on the space, we do look at SEC precedent to say, what does this mean and how should I take this forward? And I have found that to be sparse and uneven. So I will say, we can say the usual things, right? We can say bring rigor to non-GAAP metrics the same way you bring rigor to GAAP metrics, right? You can say all those things, but the enforcement on this, in my view, is uneven.
Yeah. It's an interesting point because there have been cases in 24 and 25 that were focused on, I think it's item 501 of Reg SK, right? Which historically they hadn't brought some of those cases, to your point about being uneven. So, and I suspect again from some of your earlier comments, that'll be a continued area of focus because they've used that rule set where they haven't used it in the past to bring some of these actions.
Steve, I also think there are cases in the pipeline. I mean, non-GAAP, again, if we had gone back a couple of years ago, we would have been saying non-GAAP's out there. And I think these cases are probably coming.
Yeah. Well, let's continue with the theme about disclosures in some of the accounting actions. You know, Anne, from your perspective, how might the commission think about remedies differently? An earlier panel touched upon ICs, you know, monitors and compliance consultants, but remedies relating to accounting disclosure cases. Should we expect more of an approach that was, you know, consistent 4, 5, 6 years ago, or a continuation of what we saw in the last administration?
I think, you know, there's definitely going to be a focus on individuals, and with an individual, this is not new. We have always been focused on what someone is doing and whether they're going to be able to continue to do that in a way that could potentially harm investors. So officer and director bars, I think bars from appearing or practicing before the commission, those are definitely still on the table with respect to individuals so that they can't continue to harm investors with whatever they were doing. But, you know, we're going to be looking at the right remedies, I think, for companies themselves. Each violation isn't the same as another violation, so things happen, and I think that the commission recognizes the fact that sometimes there's a mistake. There's something that maybe doesn't rise to the level of an enforcement case, but we're going to look particularly at the facts and circumstances of each situation and then make the call. Is enforcement action warranted? If so, then what are the right remedies to make sure that this isn't going to happen again? Get to the root of the problem, make sure that investors aren't being harmed. But then also, I think, with the current commission, we will be looking a lot at, is a remedy going to cause further harm to investors, or is it going to protect investors?
Yeah. You know, one of the things that we talked about in our prep session, which I thought was really interesting, and so not to put you on the spot, this is not in the questions, but I circulated Asheesh.
No worries.
I found the discussion real interesting, is a discussion around having economists talk about causation, and having a discussion with the commission around causation. And having a relationship relative to monetary penalties or something else. I think, can you give us a little flavor of some of your thinking there?
Yeah, it's funny. I'll start with an anecdote. You know, I started at the commission in the wake of the passage of Sarbanes-Oxley. So I started September of 2002. And I had spent 7 or 8 years at the time working as a securities litigator on the defense side, representing companies in securities class actions. And there, obviously, causation, loss causation are significant parts of defense to any type of action like that. And I had kind of brought that perspective to the SEC. And I remember sitting down with my assistant director at the time and discussing the elements of a securities fraud violation. And it came as a huge, like, eye-opening moment for me to realize, like, wait, the SEC doesn't care about this. They care about, is it, you know, have you made a misstatement or an omission? Is it material? Is there scienter, right? That was kind of the 3-prong approach to financial fraud, securities fraud, disclosure fraud. And so it was a while to sort of retool on that. And so when we have these conversations with our clients that have been in litigation postures, that can come as a big eye-opener. But I think where it does come into play, and I think where the SEC is actually sensitive to it, is on the harm analysis. Not as a standalone, separate, you know, did your misstatements result in harm? That's sort of the fundamental, you know, layman's definition of loss causation. But I think it does come, and you can have some of these discussions, and I'm expecting to have more of these discussions now that the Wells process is more robust, or we're expecting it to be more robust. I think you can have conversations around that concept when you're discussing, like, how to deal with remedies, right? So if you're saying, for instance, well, yeah, we said all these things, and we can argue about materiality, but we don't think it caused any harm because the share price went up. That's a pretty powerful argument, and you don't want to lose it. And so we sort of weave that into the remedies point, which is, okay, well, maybe there's no disgorgement here, and maybe it's a single dollar civil monetary penalty, and then we're done. In which case, many companies are like, do that. No, let's do that. And so it's the right case. Not every case is going to have that. But I think for defense counsel in the room, it's an important piece to remember as we sort of are back in the world, I hope, and it's all indications point to this, of having more meaningful and robust conversations around settlement. This is a significant issue that we do bring to the table.
And do you have any thoughts on the commission's willingness to have conversations around loss causation?
So, yes, I think, I mean, I'm always willing to listen. I think that's something that I've always been, sorry, the mic, always willing to listen on something. And if it, you know, information tends to be a one-way flow. We have constraints on what we can say back to you. We have constraints on, you know, what type of information we can share. But, you know, things that and I know we talked about this a little bit earlier in our prep session, but, you know, in certain instances, in the right case, I think we are amenable to thinking about how we could possibly include staff from, you know, potentially another division or office. The big thing, though, I think that needs to be said, we don't have any obligation to run our investigative steps by defense counsel. We're not going to tell when we're talking to staff in other divisions. You can assume that we're probably talking to the experts that we have in the building, but we're not going to necessarily tell you, and we're not obligated to do that.
Yeah, I appreciate that. Maybe just pivoting, Paul Helm, as you've listened to this conversation, and as you think about how you're advising your clients, and one of the prior panels touched on this a little bit, are you thinking about it any differently as you coming to your settlement posture with the commission relative to how you approach the advice you're giving your client on remedies, proposed settlement terms?
Yeah, post-settlement terms, I think I would put in two different buckets. So first, if I'm defending a corporation, you know, this is a day of lower penalties directionally. And the cases that have come out, the few enforcement cases related to accounting disclosures that have come out in this administration directionally have involved lower penalties. And so that is something I think you can anticipate. Well, what does lower mean? I think for Chair Atkins, he has, again, made several statements about how it's very important to have a transparent process and also to fit with past precedent. And so I don't think he's going to mean Chair Gensler's administration in terms of the precedent that was set there. I think when we're looking at precedent, when I'm advising clients, we're going back to Trump 1 and earlier and looking for those penalty levels and seeing if that's about right for where this thing should land. For individuals, I think it's very different. And I think, you know, we represent several individuals. It is going to be a much tougher day for representing CEOs, CFOs, and CAOs in front of the commission, because I think when they get hold of a case that they like and want to keep, it means that there is some element of true fraud or manipulation there, going back to Ann's opening comments, and that they're going to want to head. And so now all of a sudden, when it comes to settlement dialogue, you have to face the fact that they're probably going to want a bar because it's going to be a 10b-5 case as opposed to a negligence-based case. And I think I personally am going to struggle with I think you may have to litigate more to get what you need out of that dialogue, and it may not be possible to get a settlement that an executive can live with, where a corporation might be able to survive and move on with the black eye and a little bit of money. That executive, that's a real thing to them. That's their career. And that's a place where you have to fight, but probably in a case where the facts are tougher in this administration. I think that's the thing for me that's really going to change.
Well, let's talk a bit more about that individual liability since you brought it up, Paul. You know, Chair Atkins has historically had a focus on individual liability in his public remarks, certainly in his voting record. You know, and if you can give some perspectives about what are your thoughts on how the commission will think about that individual liability and how that may intersect with how they view cooperation and give cooperation credit.
So Cooperation, I think, is something that we've considered on, going back many years, not just 4 years, 5 years, 6 years. I think it goes back for as long as I've been at the commission, if it's meaningful. Now, meaningful cooperation is not responding to document requests by producing the documents, responding to a subpoena by showing up for testimony. Those are legal obligations. That's not cooperation. So the Seaboard factors from the 2006 penalty report are still important and something that we truly consider. And so it's self-policing prior to the discovery of misconduct, self-reporting of the misconduct, remediation, and then cooperation with law enforcement. So, but cooperation isn't required. The company's not going to be penalized for not choosing to take those types of cooperation steps, but that's the point. When there's meaningful cooperation, then that's when credit can be assessed and given. And so we'll be thoughtful about that. On the individual side, I think same thing. We're looking at what someone's role was, what they did ahead of time. And so all of those are really part and parcel of kind of the determination. But it is, and I hate to be a broken record on this, but it's facts and circumstances. Each case isn't exactly the same. And so we're going to look closely at the particular facts of the particular case and then weigh how the factors balance.
Yeah. Well, Paul T., let me ask how does your advice to your clients change, if at all, when thinking about cooperation, self-reporting, and considering if you have an individual versus a company?
Yeah. Let's put self-reporting to the side for a moment, because I think that is changing dramatically, tied to how important materiality is going to be to this commission and how it views materiality. Cooperation and how to just represent an individual under investigation. I think Paul Helms said it right. These cases are going to be fraud cases. And so as the former prosecutor, what I am always thinking about anytime I hear about a fraud case, it isn't so much the commission, no offense, Ann, but it is the Department of Justice and whether the DOJ is lurking in the background. Sometimes I get sometimes I get to find out that the DOJ is there, there's an assigned prosecutor, whether it's someone local or in main justice, but I don't even always get that information. One thing that's changing dramatically here, while the last panel said it exactly right, the SEC seems to be going back to basics, going back to exactly the kind of stuff that we're talking about in this panel, accounting fraud and the like. The DOJ has made a number of statements saying that they are stepping away from the essentially private fraud criminal matters. So DOJ has made it clear that they are prioritizing narco-terrorism, violent crime, things of the sort broadly across the country at main justice and in all the field offices. DOJ has also said within fraud, the kind of fraud that we're talking about here is taking a back seat. So Matt Gagliotti, the current Assistant Attorney General who runs the criminal division of the Department of Justice, back in May issued a memo listing out the department's criminal white-collar priorities. Numbers 1 and 2 on that list were frauds against the United States, where the United States was the victim of the fraud, where money was stolen from the Treasury, essentially. Item number 3 was frauds involving VIEs, and it was a thinly veiled statement by Gagliotti and the rest of the department that it's really going after China and other state actors who are engaging in fraud against citizens in the country, but also, again, against the United States itself. Only when you get to number 4 on that list do you find securities fraud that we're talking about here. So in the grand scheme of criminal enforcement, securities fraud itself isn't a priority, and securities fraud is only number 4 on the list. So as I'm advising my individual clients, if I think these cases are more on the margin, the bad case is the bad case, and I can always tell a client where I think it's a bad case, look, the DOJ is probably lurking in the background. Big money numbers, significant fraud, very high profile, that's one thing. But cases that are more on the margins, it is more likely that the Department of Justice is pulling away, is not getting involved, has already declined prosecution, which allows me to then do exactly what Paul Helms was saying and really consider engaging in litigation against the SEC, now knowing that I don't have a concern of making statements that are going to be used against my client criminally.
I think that, though, I mean, Paul, Tzur, don't you think that's actually like a good outcome, though? I mean, I think that's actually, I mean, the SEC is the principal regulator and enforcer of securities fraud. I think that actually makes a lot of sense because the remedies, first of all, I think the SEC is really well equipped to investigate this conduct. I think FBI agents can be hit or miss, right? Postal agents can be hit or miss. And so I think the SEC being the primary investigator and enforcer of securities fraud makes perfect sense to me. I also think the remedies that the SEC has are effective. And so I have found that where the DOJ gets involved on pure securities fraud style cases can be extraordinarily complicating to actually get to a positive outcome. I don't know if you feel differently.
No, I completely agree. The commission is designed to do exactly this kind of investigative work and exactly this kind of enforcement and levy very significant penalties. Just like Paul was saying, a bar on an executive is, you're taking away that person's ability for a time or permanently to actually do the job that she's been trained to do and has been doing for quite some time. I think those can be very effective remedies and have very significant general deterrent effect as well. Again, there are the obvious cases, the Skillings of the world, where you can see high-profile case, enormous amount of money, where the Department of Justice should step in criminally to put someone in jail for criminal misconduct, criminal fraud. From the department's perspective, that makes sense. But those numbers, you're right, Asheesh, those numbers should be way lower than they have been in the past. Yeah. And the commission really should be the enforcing body here.
Yeah, and maybe we'll end the panel on this question is, we're talking about individual liability cooperation. Relative to the Wells process, which we've heard earlier panels talk about what they expect the productive nature of the Wells on a go-forward basis. How does the panel think? We'll end with this question for everybody on the panel, starting with you, Asheesh.
Sure.
How do you think that the views towards greater individual liability will impact the Wells process or charging decisions, and how the commission thinks about cooperation and your advice to clients? Yeah,
I think it largely depends on who you're advising. I agree with everything that's been said so far. I think if you're advising companies, the DOJ has been explicit, the SEC has been implicit on this, but a part of cooperation historically has been identifying the wrong conduct and identifying the wrongdoer. And so when you're doing internal investigations where you've self-reported, oftentimes the SEC and the DOJ will say, okay, you've told us what went wrong, who should we blame? That's, I think, going to remain a part of cooperation, and I think that's going to remain part of the Wells process. For companies that have engaged in conduct that is chargeable by the SEC or the department, they're going to want to say, look how great we are. We've found out the problems, we've identified the wrongdoers, we've gotten rid of the wrongdoers, and we've put in new controls, what we used to call the playground rules, right? And that's going to continue, I think. And so I don't think that's going to change. In fact, I think that's going to be more pronounced now that you have a more robust Wells process, because I think companies, are expecting at least to get more bang for the buck, both from cooperation and from the Wells process. I think if you're an individual, though, you're sort of in a posture now where you're like, I'm going to fight. And so the adversity between companies and their executives can form very early. And so what we have been talking about with our corporate clients is, when these matters come in, when you have internal investigations, thinking about how you form those relationships earlier and very early in the matter. So, for example, a matter that I've been handling that I won't mention the name of, we had counsel lined up for executives the day we started the internal investigation. Most clients, we haven't historically done that, because you're sort of like, well, I'm going to want to interview this person, I'm going to go through their documents, I want access to this person. Nowadays, we sort of have been thinking, in really high-risk matters, bringing counsel for individuals on early is not only protective of the company, but protective of the executive as well, because you could decide early on, wait a minute, the individual, am not going to cooperate. So I think that's an important piece of the puzzle.
Paul Helm, last word.
She's dead on. I mean, I think exactly right. And if you look at the cases that have, again, the few cases that come out of the commission in this administration, in this space, the company is settling and the individuals are getting charged. And it's multiple individuals, and there are a lot of facts in the complaint. And I had the same thought. If you're at the well stage, it might be too late. That's a posture where you're fighting. And you really need to do the work on the front end. As soon as that executive is confronting testimony or any sort of personal document production, making sure that they have somebody who has a perspective of that individual in mind from the very beginning, not just to protect them, but also tactically and strategically, because a lot of times individual counsel can have that focus and protect everybody by making sure that that perspective is honored.
Yeah. Well, we're out of time. We could continue this conversation for hours, I'm sure. But thank you, everybody, for the time you spent, and again, and for your government service. Appreciate it. Thank you.
Thanks, Steve.